Can you imagine that? If you've been told you've got cancer, you're going to die, you're at the weakest point in your life, psychologically. And at that point, a doctor who is permitted to say, oh, but we can give you a poison to help you commit suicide. If you're ever going to say yes, it's likely to be at your absolute weakest and lowest ebb. And if you've been told you're going to die, you might just say yes. So how do you make a safeguard against that?
Right, morning, Calum. Morning, James. Thank you both for coming in. There's a couple of big topics to discuss that have been in the press a lot recently. So we're going to focus on assisted dying, and then we may, if we have the time, talk about the reforms to abortion laws recently. I think these are quite emotive subjects, and bringing you both together on this was a good idea. But I think just because of what we're discussing, it's probably best that we allow people to know who you both are, so they understand. So, Calum, can you just tell people who you are, what you do? And
Sure. Yeah, so I'm a medical doctor by background. I still practice a little bit in the NHS in hospital. I'm a researcher, so I do a lot of work on bioethics and public policy relating to issues about bioethics and family and population issues. And then I would do a lot of public speaking, a lot of advocacy work and policy work on population, families, supporting having kids and those sorts of issues. So yeah, a bit of a mix.
Great, thanks. And yourself, James?
I'm a barrister in private practice. Part of my practice is medical law and public law. And I've done quite a lot of end-of-life cases and some beginning-of-life cases. So I've had a very good insight into what's going on in the NHS and indeed in the law. I've also advised members of Parliament and peers, and I've been dealing with end-of-life issues and the law surrounding it for 40 years. So it's part of my practice and it's part of what I've been interested in for all that time. So that's basically me.
Yeah, so Joe recommended I talk to you. He was very keen that we get together, and it was a strange coincidence because only a few days previously, one of Calum's tweets had come up on my feed, and I'd pinged it over to him and said, interesting, and then spent a couple of hours on his Twitter looking at both assisted dying and the reforms in abortion law. I'm not going to claim to be an expert in either, but I think it's great that we have both someone from the legal side and a doctor to discuss this. So I think we'll start with assisted dying, and I'll probably start with you, James, and just put to you: should someone suffering immeasurably have the legal right to end their own life?
Well, the first thing I would say is it's not an assisted dying bill; it's an assisted suicide bill.
Okay. And
some would even go further and say it's a poison by doctor bill, which actually is what it is. Basically, the doctor is giving at the moment, unregulated poison. We don't exactly know what the substance is going to be to a patient who has ostensibly requested it without any real proper safeguards, even assuming that one can have safeguards. And in my opinion, you can't. Once you go down that route, you've got rid of any prospect of safeguards. But to answer your question, no, people shouldn't have to die in horrible pain and suffering. And in these days, given the quality of palliative care, medical technology, and the various drugs that we have that are lawful and are regulated, nobody needs to die in pain. If they do, it's because they're not getting the proper care that they need. And of course, that happens in the NHS because, as we know, things are going wrong in the NHS all the time. I mean, I don't know if you were aware of it, but Royal Sussex County Hospital are now being investigated by the police for something like, at the very least, 20 unexplained deaths. Not just an issue of negligence, but it's now the police are looking at it as a criminal matter, and there have been something like 200 complaints. Hitherto, one of the problems has been in the NHS that when these things happen, the police have taken, shall we say, rather less of an interest than they ought to, for the perhaps understandable reason that most people trust their doctor and trust the NHS. And the NHS has always historically had a very good reputation ever since it was created in 1948. But I think times have changed very, very dramatically. And part of the reason is certainly financial, but the combination of lack of bed spaces and lack of money, lack of doctors, lack of nurses, the changes in medical and nursing education, a whole series of factors have combined in a sort of vicious circle to put huge pressure on the NHS to free up bed spaces. And one, of course, easy way of doing that is to shorten people's lives.
So do you think this is the background to this issue?
This is definitely the background to it. No question about it at all. And we also have, of course, constant attempts by organisations like Dignity and Dying, the National Secular Society and other campaigning organisations who represent a minuscule, tiny percentage of the population, pressing with large sums of money that they are apparently being given by donors, pressing Parliament to make changes. And not only that, but bringing legal cases to try and put pressure on the system through judicial intervention so as to effectively bring about what they want, which is bills like this, or indeed they want to go further and have what they call non-voluntary, but is in fact involuntary euthanasia. Well, I'm sorry, we've already got that in the health service. Nobody's going to admit it. It would be regarded as a terrible omission if they made it, but the fact is that's what's happening, in the sense that lives are being shortened illegally. It's still a homicide. It's still a criminal offence in this country. But as somebody once said, if you wish to kill somebody and get away with it, get a doctor or a nurse to do it. And that is why medical ethical standards are so vitally important. Not just high-quality medicine, but high-quality ethics in medicine is absolutely vital to ensure that our citizens' lives are protected. And when you start to lose that, you go down a very slippery slope, which is very difficult to prevent yourself from going down. Now, this bill is simply going to accelerate that, quite apart from the fact that the bill itself is horrendously flawed. It's so flawed that in the course of the debates, every time Kim Leadbeater was asked the question, well, how's it going to work in practice? The bottom line is that she got around it, and her supporters got around it, by saying, well, we'll give more powers to the minister. We'll give more powers to the relevant minister. And what has now happened is that every time there is an issue of how is the detail going to work, the bill has simply handed over what are called Henry VIII powers to the minister, which means effectively the minister can change the law, primary legislation, by means of secondary legislation, that is to say statutory instrument, or even just ministerial order. In other words, government by diktat. Well, in any other context, most members of Parliament will be absolutely up in arms against giving ministers such powers, but apparently not in this bill. But having said that, the government has 165 seat majority against all the other parties, and it only managed 23 majority for this bill, because a very large section of the Labour Party, the governing party, rebelled against this bill. It tended to be the left wing of the Labour Party, but the likes of Diane Abbott spoke very persuasively against it, but couldn't persuade her colleagues within the Labour Party and certainly within the government. The Conservatives, I think something like 20 Conservatives voted for the bill. Conservatives could have stopped the bill if they wanted to, but they didn't. And I'm afraid the booby prize goes to the Liberal Democrats, because 75% of them supported the bill. And a lot of these members of Parliament, they're brand new members of Parliament who don't really have much experience with parliamentary debates and with legislation and making up legislation. And very, very few of them have any experience at all with end-of-life issues, either as doctors, nurses, or in any other capacity. They're simply not qualified to be able to make these decisions. And as you probably know, the people who are going to be delivering or sitting on the panel that's now going to be making these decisions, psychiatrist, lawyer, and social worker, well, certainly the Royal College of Psychiatrists have said that they cannot support the bill. And they're going to be a key figure, will be a psychiatrist. And yet the Royal College, representing psychiatrists throughout the country, have said, no, they absolutely cannot support it because it's completely flawed. So this is the problem we have. So even the answer to your question is nobody die in pain or suffering, but they've got to get that palliative care. That's what the government should be concentrating on, making sure that patients who are in severely suffering conditions get the palliative care that they need, not saying, well, sorry, mate, there's nothing we do for you, so here, take this poison and kill yourself. And how do we know for certain that they are actually going to kill themselves? Will the doctor say, well, just, here's a straw. Oh, you don't seem to be going it right. Let me help you out. And then now suck on that. Or, oh, that doesn't seem to be working. Here, let me pour it down your throat. We just don't know how that's really going to work. This is another thing where the minister has been given Henry VIII powers to decide how it will work. But the bottom line is, if there's only the patient and the doctor and nobody else is watching, and that could very easily happen under this bill, we don't know whether the patient has been killed by the doctor or has actually been assisted to commit suicide. That's just one example out of dozens in which this bill has just simply not got anything remotely resembling safeguards. And I'm not sure that it could ever have safeguards anyway.
Calum, as a doctor?
Yeah, I think it's obviously a profoundly dangerous bill. We know that most people who undergo assisted suicide, we're told this idea that they're dying in horrendous pain and suffering. They give these examples of people drowning in their own feces, this sort of thing. The reality, when you look at countries that have done this, is that the large majority of people who undergo assisted suicide or euthanasia are doing it for more existential reasons. They feel like they're a burden. They feel like they've lost their autonomy or their dignity. And very few of them have physical pain that is intractable. And we know that with good quality care, physical pain is treatable and physical symptoms. There are even possibilities that might make some people a little bit uncomfortable, but don't mean killing the patient, like putting them in, an unconscious state for a certain amount of time so that they feel nothing at all. There are not necessarily perfect remedies. And like I say, people might be uncomfortable with that, but there's certainly no need for killing patients. And so the idea that this would come into practice would be something that I think, people have mentioned a lot of times, that this would fundamentally undermine the doctor-patient relationship. And that is true. Once you open the door to killing as a doctor, which is the opposite of the medical vocation, you are fundamentally changing the nature of medical practice in a way that is irrevocable and that it inevitably will filter throughout the rest of the medical system and the rest of people's thinking on these sorts of issues.
That's the Hippocratic Oath? Was it?
Yeah, it says first do no harm, and killing is obviously harmful. So a lot of people mention that, and the Hippocratic Oath says all sorts of things that people who've never read it are sort of unaware of. It also says I won't do abortions and that sort of things. We might get to that later. But yeah, I mean, the Hippocratic Oath has already been undermined in that sense, but to further undermine it by just allowing doctors to do the very opposite of medicine by killing patients, at the end of their life as well, is really quite horrifying and frightening.
It's interesting to see the vote here, like Connor's presented up, because it's a bit more visceral now. If the 5 Conservatives who did not vote and the 20 who voted for had voted against, this would not have passed.
That's right.
Yeah, it's interesting to see it like that, and interesting to see how many Labour's members voted against it.
Yeah,
and I
look how many Liberal Democrats voted for it.
Yeah,
56, and only 15 voted against. My member of Parliament, Paul Kohler, and I'd like to pay tribute to him, is a Liberal Democrat, but he was one of the 15 who voted against and made a very, very good speech and sent out a number of letters, sending me copies, which were, I think, among the best I've seen from members of Parliament. I just wish that his colleagues had listened to what he said, but unfortunately 56 of them didn't. And if even... Well, all we needed was 12 of those Liberal Democrats to vote against, and that would have been the end of the bill.
End of it, or they would have gone back with revisions?
Well, if at third reading you vote for the bill.
Okay.
So if they had voted against it, that would have killed the bill. Instead of which they're going to kill the patient.
So I see a place for conscience in parliamentary votes, but I also think it's overly used by party leaders as a way of abdicating their responsibility and abdicating responsibility to take any position. I mean, Kemi Badenoch basically comes out at the very end every time, after all the public debate, sometimes even after the vote, and sort of takes this bold stance against euthanasia or whatever. In reality, she showed no leadership on these issues at all. She was a patron in the past of a euthanasia advocacy group. And so I think, party leaders, yes, can put votes to conscience at certain times. But on issues like this, if you're a Conservative party, upholding one of the most fundamental human rights there is, and upholding one of the most fundamental traditional values of our country, which is the sanctity and dignity of life, I don't think as a Conservative leader you can get away with just saying, oh, it's a personal issue, it's a conscience issue. This is something that the Conservative Party absolutely should have whipped on, and that, like James said, if they had done so, we wouldn't be in this position.
James, is it set by the party whether it's a free vote? Could the Conservatives have whipped their...
Oh, yes.
They could have.
Of course.
So every party just chose to have
Yeah.
a free vote.
Yeah, and it's as Calum says, it's a moral cop-out. And it often happens on these very controversial bills. I mean, if there were votes, say, on capital punishment, but for the fact that the majority of the parties will be against it, but if they weren't, they would do the same thing. They'd say, oh, no, we're not going to make a government bill. No, we're not going to whip people. They can have a conscience vote if they wish to get it through. So that gives you a parallel to show you the sort of way in which they operate and the way they think about these particularly controversial bills. In order to avoid having to say, well, this is a government bill, and be criticised by the media when it all goes horribly wrong, what they do is, oh, well, it's a conscience vote, it's all down to the conscience of MPs, knowing how the vote is going to go. Although I think the government got a very severe surprise when 160 Labour MPs voted against it, and they only had a majority of 23. They were pretty sure that their massive majority in the House of Commons was going to cause the bill to go sailing through. Well, of course, as soon as MPs got into the detail of it, it became absolutely clear to members of Parliament, those who were open-minded, that it's completely unworkable. And so instead of getting into the detail and debating it properly, which is, after all, what parliamentary chamber debates are about, they've simply said, oh, we'll leave it to the minister, and given the minister Henry VIII powers. So he's going to be faced, or she is going to be faced with the problem of how do we make this work? And it won't work.
Can it fail in the Lords? Can it be rejected in the Lords?
It could still fail, yeah. But, I mean, there are various conventions governing how the Lords deals with bills that have gone through the House of Commons and been voted in favour of the Salisbury Convention. For example, it's a convention only. The Lords could rebel against it, but conventions are what make up our Constitution. So breaching a convention is effectively getting close to breaching the Constitution. But the Salisbury Convention says, if the bill has gone through, provided it was in the manifesto. Well, this is not in the manifesto. And frankly, if it had been, I suspect the Labour Party would have got rather less votes than it did get. But this is what so often happens with these kinds of, particularly end-of-life, beginning-of-life bills, is that nobody says anything in a manifesto. It's not put to the people. The people don't get a chance to vote for it. It's brought in later by a private member's bill. And then the government says, oh, well, this is a conscience vote. Sorry, I had to leave it to the end. Knowing they're going to get the support of 56 members of the thereabouts of the Liberal Democrats and at least some Conservatives. And as Calum says, the Conservatives could have and should have opposed it if they were in any way responsible, behaving responsibly. But no, they just let it through. So to answer your question, in the Lords, leaving aside the issue of the various conventions governing what the Lords can and can't do, yes, the Lords can make amendments. And in fact, the debate can be often more incisive, more in detail, more in depth, because they have more time to debate these bills. And because members of the House of Lords, unlike members of the House of Commons, have a much, there is a more open opportunity for backbench peers to table amendments. And provided they do so within 48 hours of the debate, there's a chance that their amendments will be debated. And that's another disgraceful thing about this bill in the Commons, is that at second reading we were told, well, we're just debating the principle. We'll get into the detail later, and they haven't got into the detail at all. And particularly when it went back to the whole House, debate was curtailed. I mean, I think there was something like 133 amendments, of which something like, 11 or 12 were in the end voted on, and 8 of those went through on the nod because they were neither plus nor minus as far as both sides of the debate were concerned. So only, what does that leave? 4 or so amendments that were controversial were debated. The rest were just simply allowed to drop by the Speaker, including, I might add, 2 perfectly reasonable amendments by Paul Kohler, a member, the Liberal Democrat member for Wimbledon, who is opposed to the bill. No, he wasn't even allowed to have his amendments debated. Now, the argument was there should be a closer motion because a lot of the amendments were wrecking amendments designed to prevent the bill going through by wasting parliamentary time. And that's not true either. A great many of them were, the amendments were tabled by people in very good faith, members of parliament in very good faith, including those who were not opposed to the principle of assisted suicide, but could see that this was an extremely dangerous bill with no real safeguards. And their amendments, which were good faith amendments like those of Paul Kohler, and by the way, Paul is not opposed to the principle of assisted suicide, but could see very clearly the dangers of this highly dangerous bill and wanted, at the very least, to try and add some reasonable safeguards. Not debated. The Speaker wouldn't allow the debate. All because the government, who pretends that this is a conscience vote, and surely if it's a conscience vote, you're going to allow people to debate it as fully as they require and need. Nope, they just curtailed the debate in order to push it through, which means that it's not really a private member's bill.
Well, it
it's
does
more
feel
of
rushed.
a government bill.
It does feel rushed because the first reading was while we've been making this show. It feels like, was that about 6 months ago? Was the first reading 6-7 months ago?
Yeah, probably about then, yeah.
Yeah, for something so profound, something so important to society, it feels like it's gone. It just feels like it came out of nowhere for me, and has happened very quickly. Con, can you just look up the Hippocratic Oath and just see the parts which may relate to this? Just over to you, Calum.
By the way, just your reaction is, in fact, exactly what happened. It came from nowhere, and it was rushed through the House. So your feeling that this is what has happened is absolutely bang right.
It just feels like something we should have debated for potentially years.
The humble bee, a keystone species crucial to the survival of Earth's inhabitants. Here's how things would look if bees vanished. And here's how they'd look if humans vanished. But imagine if instead we became a keystone species by doing things the right way, by taking responsibility for our actions and becoming the solution. Iron mines, the world's most responsible currency, the right way. Because the future depends on it.
On that theme, I mean, yes, we had, less than a year of this government, nowhere in the manifesto, nowhere before the election. Within a year, they've, through the Commons at least, legalized assisted suicide and abortion up to birth. The abortion up to birth, there was even less debate. This one at least, nominally had 3 readings and a bit of debate. Abortion up to birth had nothing in the media, had 46 minutes of debate in Parliament, and now it's passed. So it's with both
rapid
issues, and both of these are absolutely sort of fundamental changes to our moral code as a society.
So just help us understand, what does the Hippocratic Oath actually mean to a doctor?
I would say that candidly, its significance is sometimes a little bit overstated in the sense that most doctors do not say it anymore when they qualify. And there's a perception that it's sort of a passage of, rite of passage, sorry. The reality is it's sort of gone out of fashion in any case. But the principles are still absolutely essential and have been incorporated into the World Medical Association's Declaration of Geneva, which is sort of a modern day Hippocratic Oath. And even that has been watered down over time and so on. But it's supposed to have preserved the principles, and the principles are still widely regarded. Do not have inappropriate relationships with patients, do not harm the patient, things like this. I would keep things confidential.
So I'm just going to read some of the bits from here that Connor's brought up so people are listening. Of solidarity with teachers and other physicians, of beneficence and non-malfeasance towards patients, not to assist suicide or abortion, to leave surgery to surgeons, not to harm, especially not to seduce patients, to maintain confidentiality. I mean, that's quite explicit, not to assist suicide or
I
abortion.
don't remember the exact wording in the Hippocratic Oath.
Can you try and find the exact wording, Connor? Because that's like a summary. But at the same time, this is something I'd expect. But is it a case that it shouldn't have gone out of fashion?
I think so, absolutely. And I wonder if part of the reason is because it includes, prohibition on abortion, which is obviously very controversial in the Western world. And that's probably, it's very explicit about abortion in the Hippocratic Oath. And I wonder if that's a big part of the reason that they've sort of tried to say, okay, we don't really follow this anymore. But I think the fact that it has been preserved through the Declaration of Geneva, that people still know about it, that it's still referred to so often, is a symbol or an indicator that even if, doctors are no longer forced to do it and it's being sort of pushed out in some ways, society kind of knows deep down that the fundamental principles of it are still very important, and they still define what it means to be a physician and what it means to practice medicine. And so for that reason, yes, I think we should, even if you don't force every single student to say it, I think we do need a recognition that this is the foundation of medical practice and what it should really involve.
Here we go. So
there we go. Yeah, I will neither give a deadly drug to anybody if asked for it, nor will I make a suggestion to this effect. So it's very explicit.
I wonder if it kind of gets around that. I will neither give a deadly drug to anybody if asked for it. Maybe they're not asked. Maybe they're told by legislation.
You can only give it, right.
Yeah, nor will I make a suggestion to this effect. Well, if 2 doctors are voting on it, they will, and they vote for it, they will be making a suggestion.
Right, and the law specifically allows doctors to raise this with patients, even if the patient doesn't ask for it. It allows doctors to.
Yeah, can you imagine that?
To introduce the subject, which is totally insane.
Can you imagine that? If you've been told you've got cancer, you're going to die, you're at the weakest point in your life, psychologically. And at that point, a doctor who is permitted to say, oh, but we can give you a poison to help you commit suicide. And if you're ever going to say yes, it's likely to be at your absolute weakest and lowest ebb. And if you've been told you're going to die, perhaps a painful death, and you needn't, as I say, but if you've been told that you are going to, you might just say yes. So how do you make a safeguard against that?
Well, but this is, I brought it up to Calum before we started. I mean, I have a friend I went to school with. Sadly, he has passed now, but our mutual friend told me about when he had cancer. He said it was so serious, it got to the point where he was told, oh, he's not got long left to live, you need to come and see him. And then Tom always refers to this as a miracle. He said then miraculously he started to get better, and then he went into remission and he lived another 20, I think, years.
There you go.
And, we have a relative connected to our family who was given months to live on immunotherapy, has lived for 4 years. I watched a Louis Theroux episode, whereas a guy was deemed to have be in a vegetative state, no response from his brain. And then Louis went in there a week later because he had responded and he was up and walking. Like if you talk about 6 months, it weirds me out because I know there can be misdiagnosis, and you'll answer this better, Calum, but I also know there are treatments treatments can work. Treatments are complicated, right? There's no guarantee of successful failure, but you should probably just take over from me here.
Well, before I get to that, I want to mention that this worry about, doctors raising it to patients is not just theoretical. In jurisdictions, it's exactly what we've seen outside the UK. So in Canada, there are many stories where, someone will say, I think if they call the Veterans Affairs, I know one story of a Paralympian who was paralyzed during their military service. They called asking for a chairlift or a stair lift for their house because they said, it's really bothering me. And after a while they said, we still haven't got it. I can't go upstairs. It's really causing difficulties to my life. And they were told, well, if your life is so bad as a result, you could consider assisted suicide.
MAID is there.
Yeah, MAID, medical assistance in dying. So the euphemism is standard. And she's not one example. There are many such examples. I've met people like that in Canada who've been just offered that. Even in this country on abortion, people will say, oh, the doctor will never suggest it. But if you pretty much anyone who has a child with Down syndrome in this country knows that when your child is diagnosed with Down syndrome, the doctor will advise you to have an abortion. Sometimes 10 or 15 times, we've heard in some cases.
I remember when Connor's mother was pregnant with Connor, they said to us, there's a test you can do in the pregnancy to tell you if Connor has Down syndrome, so if the baby does. And we rejected it because I remember it specifically saying, why would we want this? It's like, well, you can consider maybe you would terminate the pregnancy. I was like, well, we wouldn't do that.
Yeah.
And so we didn't even have the test. We rejected the test.
Right. I mean, there are cases where not only have they suggested it straight away, we know of cases where a woman's baby has been diagnosed with Down syndrome and an abortion appointment has been made for her 2 days later. And they said, your child has Down syndrome. We've already booked an abortion appointment for you in 2 days. So everything's fine.
I remember.
I
remember an abortion that was related to a cleft palate.
Yeah, there are a few of those a year. It's not a totally unknown thing.
Here we go. Paralympian claims Canada offered to euthanize her when she asked for a stair lift. I have a letter saying that if you're so desperate, madam, we can offer you medical assistance in dying. Is there does that come from a government body or is there a private institution that provides this? And the reason I ask that is I know, for example, with the trans issues in America, with children being offered the ability to go through the medical changes if they're deemed as trans, that there was private companies who were monetizing this. And so they were incentivized to try and convince parents of children they should be. Is there a private model in that at all? Is it all public?
It's certainly a risk, and James would be able to comment more on what the law would allow in this country. But in this case, I think it was the government. I think it was the Veteran Affairs Department. And the government certainly usually does it. But I'm sure that the bill in the UK would leave space for private advertisers to start promoting it and pushing it. I don't know if they could even target ads on Facebook. So, if you show an interest through your Google's history or your social media history of having some sort of condition, probably they could target on social media those people and sort of push them towards this, which is it's like Black Mirror.
Yeah,
but it's actually happening.
Look up Dignitas, Connor. Actually, can you find out, because they're a private company, Dignitas, aren't they? I'd be interested to know what their revenues are and also how they sell it on their website, how they advertise it.
Well, you've seen some of the adverts in Canada where they basically advertise on the television assisted suicide.
Do they?
Yeah.
No, I haven't seen this.
They're absolutely chilling, and they sort of present it in this very flowery way. I'm so glad I have the chance to. It's someone who's genuinely, going to use it. They say, I'm so glad I can have this moment in peace. And they have their granddaughter there saying, I'm so happy for grandma. This is wonderful. And it's an advert for killing her.
That is so
it's
so weird.
Insane.
Connor, you got to try and find that as well. Sorry, I'm loading a lot up into you there. Within the medical profession, is there what's the kind of consensus on this? Because I assume there are some doctors who are supportive and some that are against it, but what's the general consensus?
Yeah, it's often hard to tell because the bodies that often speak for doctors are almost all kind of captured by radicalists, whether it's the British Medical Association or the Royal Colleges and so on. But we do have surveys on this, and they show a wide disparity depending on the specialty. So the average doctor, I think the largest group of doctors is against it, and then there are some who are neutral, some who are for it. In palliative care, which I think is the most relevant because these are the doctors who see patients at the end of their lives. They know how often palliative care works or doesn't work. They know how common it is for people to drown in their own feces, which is never. They also know the pressures that these people face. They see the families around them pushing for them to sort of pass away quicker, or the abuse that happens within those families. They know what support is needed and what risks there are. In the survey of palliative specialists, 90% of them were against this. So for me, that is indicative. I mean, you don't get many things that pretty much all doctors agree on. And certainly there are many doctors who support this, but with the doctors who know most about the end of life and what it involves, the pressures, the risks, the problems, if 90% of those are against it in a country that is otherwise very liberal and in a profession that is otherwise very liberal and progressive, that I think really tells us something about how dangerous this is.
What is considered palliative care?
Can I just say one thing?
Yep.
This bill is not liberal or progressive.
Of course, yeah.
It is absolutely the opposite. It is highly illiberal and highly regressive.
Right, we're going to come back to that. When is it considered to be palliative care? It's not for my mother when she died. Palliative care was the moment where she went to hospital. We know she wasn't coming out, but can it be? Is it from the moment there's no more treatments that will work, or?
It is really much more broad. So palliation really just means easing symptoms. It means kind of non-curative. And so you can have, we don't typically call it this way, but you can have palliative care for conditions that are totally treatable. As long, like paracetamol for a headache is palliative in a way.
Right.
I remember getting a hospital letter where the specialist had said that my symptoms had been palliated. Like, I think if I wasn't a doctor, I would have been horrified and sort of extremely worried.
I think the general use, though, and understanding is people consider it
generally people use it to mean end of life, and even doctors would generally use it that way. It's sort of antiquated to use it in the broader sense, but it does mean just easing symptoms. So that can be if you have a terminal diagnosis with a few days left, but it can mean if it's terminal diagnosis when you have 6 months left. It might mean a non-terminal diagnosis. So it really captures the whole breadth of it, even if it's usually used in the sort of end-of-life context.
Yeah, because I mentioned my mother, and I remember she had ovarian cancer, and she was stage 3C when they found, and they thought about a year and a half. She ended up having 2.5 years. She went vegan. She tried everything. She was fantastic. The last 6 months were particularly difficult, where we saw a significant downturn. The first couple of years, you wouldn't have known she had cancer, and then she started to look frail. And there were moments in the final weeks where she was rushed into hospital a few times. But she still had a standard of living. While it's tough for her and tough for my dad, they still had time together. We still had time with her. It was really just the last few days which were particularly difficult, where she was just in and out of consciousness and wasn't able to say much. And so that 6 months weirds me out as well, because I think of we actually still had good times with her, and she certainly didn't want to go early, and we wouldn't have ever considered it. So I find that 6 months, I don't know, it feels kind of arbitrary.
It very much is. And I think a couple of things to say. One is you can't set these sort of arbitrary limits. You know, if the fundamental principle is we need to have compassion on people who are suffering and people need to have choice over their own bodies and their own death, putting a limit of people who have 6 months left to live is totally illogical and irrational. And it's cruel. You're saying that people who only have 6 months of suffering or less left can have that suffering removed and be killed. But people who have a year or 2 or 5 years of intolerable suffering left have to go through with it. Does anyone really believe that, you know, the people who push for alleviation of suffering through killing are going to sit back and say, okay, if you've got 5 years of intolerable suffering left, you have to deal with it? Of course not. Of course they're going to push for that to be
slippery slope.
Exactly. So the slippery slope isn't just a sort of accidental phenomenon. It's inherent in the logic of the arguments these people are using, and the advocacy groups are already pushing for it to go further.
Right.
There's also another point, and that is diagnosis and prognosis is not an exact science.
Yeah.
Pardon me for stepping on your toes. It's a medical issue. But the fact is, there isn't a doctor on the planet who will say, oh, yes, we can say with absolute certainty you're going to be dead in 6 months' time.
Right.
You simply can't say that. And there are endless examples of people who've been told, well, sorry, you'll be dead in 3 months' time, 4 months' time, 6 months' time, a year's time, 2 years' time, and they're still living 20 years later. Even in extreme cases, I mean, the one that springs to mind for me is Mark Newton, years ago now, was diagnosed as being in permanent vegetative state, which, by the way, does not mean he's turned into a tomato or a capsicum or a cucumber. It means he has only his vegetative functions. It's a bad expression to use, vegetative state, because it doesn't mean what people think it means. But it is a very serious, minimally conscious state, if indeed worse than that. And that's what he was diagnosed as being. Now, obviously, it was a misdiagnosis, given what subsequently happened, but that's how he was diagnosed.
What subsequently happened?
And what subsequently happened was the doctors were about to remove his food and fluids, so that he would then die of dehydration, which is, by the way, a thoroughly nasty way to die. When his mother intervened between the doctors and her son and said, could you give him some more time? At which point Mark said, Mum. Now, if you're in minimally conscious state and still more PVS, there's no way you could even think Mum, let alone say it. And so they had misdiagnosed him. He would have been dead in days without fluids. In fact, he made a full recovery, almost entirely full recovery, and went on to study at tertiary level and got himself a degree. Wow. Some people, he went to Huddersfield Polytechnic, and some people very rudely said that was proof positive that he was in PVS. Sorry, Huddersfield Polytechnic, I don't agree with them. But the fact of the matter is, the real issue here is he was misdiagnosed in a condition that is extremely serious. Now, if you can do it in those circumstances, you can do it in 1,001 other circumstances. And you gave an example yourself of the chap who who live for another 20 years. And there are endless examples like that.
Did you find yourself during this and considering this? Have you found yourself wrestling with it yourself, or have you always been, fully against it?
Against what?
The idea that somebody
Assisted
would whatever term would want to end their life because it's
Well, I think that's a bit of a distraction. What my personal opinion about suicide is, I think the important thing for your viewers and listeners is what will be the effect of this bill, and not only on the patient, and particularly vulnerable patients, but on our health service, upon doctors and nurses. Because the whole point of the principle of non-maleficence, enshrined and encapsulated in the Hippocratic Oath and in the Geneva Convention and numerous other medical ethical foundational documents, is that the whole point of the medical and nursing professions is to cure and to alleviate suffering, not to kill, not to terminate.
But some would say termination is alleviating suffering. That's what an argument may be.
Yeah. Some people might say that. It's not, as for the reasons I've already given, as a completely unnecessary way to deal with pain and suffering, because pain and suffering can now be dealt with by modern medicine very adequately so that nobody need die in pain and suffering. That's the really important point. But the additional important point is, well, fine, even if that were true, you don't get a doctor or a nurse to do it. That's not what doctors and nurses are for.
Could a doctor or nurse reject it?
If you have a state-authorized individual who is going to terminate somebody's life, he's called a public executioner. Now, when I was in the Diane Pretty case years ago, back in 20-odd years ago, in the High Court and Divisional Court, one of the questions Lord Justice Tuckey asked Philip Havers, who was acting for Diane Pretty and her husband, she wanted her husband to be allowed to assist her suicide.
Oh, was that the couple who went to Austria?
No, that's a different one.
I still remember this, but that was
because
20 years
Diane
ago.
Pretty died without pain and without
remember the case
without
20 years
euthanasia
ago.
or suicide. So all her fears were completely unfounded, as, by the way, was Annie Linsell in the 90s, when her application was refused. And we've gradually seen the courts changing their minds, rather like Parliament. But what happened in Diane Pretty's case was Philip Havers was asked, so what you're saying, Mr. Havers, is the right to life implies a right to die. There should also be a concomitant right to die. And Havers said yes. And he said, well, if that's the case, if there is a right to die, Mr. Havers, then the government has got to provide an official person who is, in effect, going to be the public executioner for people who have chosen and wish to be assisted with their suicide. And Havers didn't really have an answer because, of course, the answer is yes. If you have a right to die under the European Convention and under UK law and under the Human Rights Act, the government has got to provide provision for it. Well, as a result of perhaps that question, but a great deal more, not a single judge, and it went all the way to Europe, to the European Court of Human Rights, not a single judge found in favour, because they could see all the dangers if a decision like that were made. Now we have this, in this terminally ill adults end of life bill, this assisted suicide bill. Effectively, this has brought it in by parliamentary legislation. And so we now have a body. Well, first of all, there's going to be a VAD commissioner, a voluntary assisted dying, which really is voluntary assisted suicide, commissioner, a public official who's going to supervise the suicide of citizens and also supervise a panel consisting of a psychiatrist, and the Royal College of Psychiatrists have set their face against this bill and said there isn't a psychiatrist on the planet, or at least in this country, who's going to want to participate in this. A lawyer, well, there may well be some lawyers, and a social worker. And again, this will be a publicly appointed body who will effectively be suicide commissioners. So the safeguards, the dangers that were highlighted by the judiciary, looking in detail at particular cases and seeing the particular problems that each individual case will arise, have just been completely ignored. Completely ignored. By whom? By a group of MPs who have only recently come into Parliament, the vast majority of whom, 97, 98, 99%, have had nothing whatever to do with end-of-life care, end-of-life cases, whether medically or legally, and, frankly, don't know what they're talking about. But those are the supporters. Those who are against the bill have said, well, hang on a minute, can we get into the detail here? You said at second reading this was a matter of principle, we're going to get into the detail later. And we've been told, well, there'll be plenty of time in Parliament for us to get into the detail and to look at the weeds of this and to see exactly how we can ensure that there will be protections. Swept aside. And what's happened? Both with the help of the Speaker, what's happened is the promoters of the bill have said, oh, let's leave it all to the Minister. Henry VIII Act. Exactly the kind of Henry VIII powers that MPs in Parliament in most other situations would absolutely set their face against. If you have a lot of those sorts of powers delegated to a minister, this is the sign of a rotten bill, regardless of the subject matter. This is a rotten bill. It should never have been passed in the House of Commons, and I hope will never be passed by Parliament.
Calum, could doctors reject, or would they only select those on the panel who are open-minded to the idea?
So my understanding at present is that doctors are given ability to refuse to be directly involved with it.
But only doctors. Nobody else.
Doctors, but also they still have a duty to sort of refer onwards, which to me is crazy. And we have this in the abortion issue as well, is that they say you don't have to do it, but you have to refer onwards for it. If you think this is harmful to a patient and you think this is killing a patient, you are not going to be happy, you're not going to be okay referring onwards. So someone comes to me, I'm allowed to say, look, I'm not going to help you commit suicide, but I can send you to someone who will. That is still just as much a violation of my conscience as getting me to inject the poison myself.
So what are your options at that point?
The options really are to refuse and risk losing your job and losing another doctor from the NHS, or
so that's a serious
or have
risk.
Your conscience violated.
You could be struck off.
Absolutely, I'm sure.
Well, I don't know. You might be struck off. You might, but you will certainly be in danger of losing your job.
Yeah,
but that feels
and that's
like...
what I already have to do with abortion. I refuse to refer for medical reasons, and I think that I have a legitimate legal argument. But there's a risk people see it a different way and just strike me off because I won't be complicit in something that goes against my deeply held beliefs.
But I don't feel like I've seen that in the debates.
Mm-hmm.
It was raised by a number of members of Parliament and swept aside by accumulated vetoes. She said, oh, well, there's a conscience clause for doctors.
Right.
Well, it's not really, as Calum says, it's not really a conscience clause. If you have to refer on to another doctor, knowing that doctor is going to proceed, then effectively you have practiced bad medicine.
Right.
Bad medicine is, I want to harm my patients. Completely drives the coach and four through the principle of non-maleficence and of beneficence. But of course the whole bill does that. So it's not much of a conscience clause. It only applies to doctors, not to nurses, not to care homes. So the problem you're now going to have is that in medical practices, nursing practices, in care homes, if a particular individual says, well, I'm quite happy to participate in the process, if a doctor says, I'm quite happy to participate in the process, and you sack him, he will have probably an open door to sue you in the employment tribunal, or perhaps in an even wider scope. We don't really know because everything's been handed over to the minister to determine what's going to be, how it's all going to work out in practice. So,
which minister?
It'll be probably Secretary of State for Health. So, and that means a whole parcel of civil servants will sit down and try and draft some safeguards that won't be safeguards. But the bottom line here is it's not going to make a huge amount of difference. The fact of the matter is, when the issue was raised, it was virtually dismissed. Oh, well, there's enough there. That's it. That's all you need. And of course, it's nothing further than truth. Yeah, the same, by the way, applied to people objecting. I raised this, and so did Baroness Sheila Hollands in the debate, and that is, what's the role of the coroner? What's the coroner going to do? Is the coroner going to be allowed to investigate these deaths? Well, if you, for example, if in the case, let's take the example of abortion, for example, if an abortion results in a live birth, that has to be referred by the doctor to the coroner. The coroner may or may not, and as long as the child has died, but is born live and then dies, that has got to be referred to the coroner. Must be, as a matter of the rules, by a doctor. That's not going to apply in this case. Supposing somebody takes the poison and doesn't die, or dies later, or even if they do die, what's the role of the coroner? And when this was raised with Kim Leadbeater, there's no role for the coroner here at all. This is all now law. This will be legal, and because it's legal, there's no role for the coroner. Well, there are all sorts of situations which one can envisage where a coroner would have to be involved because, for example, the panel may have approved wrongly. And by the way, there's no right of appeal by the family against that. And of course,
what would the family be appealing?
Well, if the family's appealed a decision by the panel to allow the assisted suicide to go ahead,
so if
did
I disagreed,
so wrongly,
yeah, okay,
there's no provision for appeal against that at all. Whereas if they refuse, there is provision for an appeal. The whole thing is skewed towards death and not life, completely contrary to the whole principle of medical ethics enshrined both in the Hippocratic Oath and also in other, the Geneva Conventions, the Geneva document and others. And if the family are concerned, there's nothing they can do by way of an appeal. So far as the bill says, perhaps the courts may allow a judicial review because it's a public body. We just don't know. But on the face of it, because this is a statute and it's therefore lawful to do what is currently extremely unlawful, then people will say, well, no, that's the law. It's allowed. Sorry if it's all worked out badly, but that's the law. And that is a classic example of rotten legislation when things can go wrong. There's nothing you can do about it. Absolute classic, particularly if you're talking about taking somebody's life. That's the most serious form of a rotten bill that you could ever imagine. I mean, consider vulnerable people, somebody who is mentally ill, somebody who is under coercive control, which, by the way, is a criminal offence in other contexts, somebody who is elderly and frail
and wealthy,
and who feels that they are a burden.
Yeah.
I'll cite in a moment, if you give me the opportunity, from a number of cases where the judges have very wisely gone into the detail of this, particularly Lord Sumption in the Supreme Court. If you, for example, were to have an elderly person, they're sitting in another room, they can overhear, their hearing is still good enough for them to hear the rest of the family in another room discussing what are we going to do with Granny. And even if the family have no intention whatsoever of suggesting to her that she shorten her life or doing anything other than what is absolutely the best for her, the mere discussion about what do we do with Granny creates or might create in the mind of that elderly person, oh, I'm a burden to my family. It's going to cost a lot of money. And here's them discussing the cost of a nursing home and a care home. Oh, dear, think of all that money. Oh, dear, perhaps I'd be better off dead. They're then going to become very vulnerable to a suggestion by a doctor. And let's not forget, as Calum rightly says, the doctor will be allowed to make the suggestion to encourage a suicide. That vulnerable person is going to be in a situation where they might end up saying yes when they really mean no. And if the panel then says, well, they've said yes, so I can't see any other objections, and the family says, well, hang on a minute, that's not what we wanted for Granny, and Granny doesn't really want that, there's nothing they can do.
The actual process, so it's a psychiatrist, 2 doctors and a lawyer. Can the process from start to finish happen just through the medical system then without any judicial oversight?
Yep. That's right. They were going to have judicial oversight. They were going to have, it was going to go to a High Court judge. The High Court judge would then say, have you ticked all the boxes? Well, that's not what High Court judges are for. Yeah. High Court judges hear opposing arguments of a case and decide which is the more persuasive case and which is in the public interest if it's a public interest case, and all the other criteria which judges have to apply when they're making a judicial decision. It's no part of a judge's role to say, well, can I look at the form? Have you ticked all the boxes? That's not what judges are for. And the objections were made by judges, in particular, the most relevant judge you could possibly imagine, and that is a former president of the Family Division. And these cases, hitherto and probably in the future, tend to end up in the Family Division of the High Court. Sir James Mumby, now retired. Because he was retired, he was in a position to comment. And he wrote 2 papers, and I've got them here, in which he went through with a fine-tooth comb and said, you have got to be kidding. This is not the role of a judge. and set out all sorts of examples, citing from cases, citing from actual case law and actual particular cases where the bill was very seriously flawed, but mainly making the point, this is not a job for a judge. So Kim Leadbeater dropped that part from her bill. And during, I think, the second reading debates or after, may have been committee stage, I can't now remember, she put in place a whole new particular raft, which is to say, oh, so the judges won't do it. All right then. We'll appoint a public official called the Voluntary Assisted Dying Commissioner who's going to do that. Good luck finding somebody who's willing to do that particular job. And he's going to oversee a panel of psychiatrists, social workers and lawyers who will have the job not of exercising discretion. They won't be allowed to exercise any discretion at all. They won't be able to say, well, hang on a minute, I'm not sure that this person really means yes. They won't be able to do that. It will be a box-ticking exercise. They will simply see, have the boxes been ticked? And that will give them a very, very little wiggle room.
Commoditizes life. We're just commoditizing life.
Exactly. And so they'll have to say yes. Now, for that reason, the Royal College of Psychiatrists has said, no way, mate, we're not doing that. You want somebody to do your dirty work, you're going to get somebody else to do it. We're not doing it. And the Royal College of Pathologists, and a whole range of organizations that care for people in those sorts of stages of life where they've got terminal cancer or they're elderly or where they're suffering in some other way, have said, no way do we back this bill and no way are we going to be involved in it. And yet they may find themselves forced to be involved. I think the only thing that has been changed is that those who voluntarily stop eating and drinking and suffer malnutrition as a result, which then affects their ability to consent properly or at all, there is now provision that they can be excluded. But that's all. If you're depressed or suicidal, if you feel you're a burden, if you live in an area where good palliative care is not available and so you do start to suffer pain and suffering when you shouldn't, or if you have suffered from drug or alcohol abuse which disorientates your thinking, or you have refused treatment, not understanding the nature of the treatment, all of those people will qualify for effectively non-voluntary suicide. Well, at least questionably voluntarily suicide.
And that's not just an oversight. There was an amendment that didn't cover all of those, but there was an amendment that said something like if you're, feeling like financially you're being pressured to do this, if you're under coercion and so on, you are you're feeling like a burden, you're automatically excluded, and they explicitly voted against that amendment. So this wasn't just an accident that could be cleared up. They've chosen to include these people very specifically.
And coercive control. Coercive control in other contexts, you can go to prison for. I was advising a client the other day who I didn't. She didn't want to carry on with the case, and so I didn't get into the full weeds of it. But the bottom line was that she went to prison for a considerable, certainly over a year, for coercive control within her family. I think it was a manifestly unjust decision by the courts. But the fact of the matter is, a criminal offence.
Yeah,
but not under this bill.
Calum, how real, from your side, do you see it is a pressure on the NHS which is pushing this through? Because look, we know the NHS is in a terrible state at the moment. Mm-hmm. I think every single government, ever since I was a kid, is committed to more spending. We always hear another 20 billion for the NHS. Yet we seem to have longer wait times. We seem to have worse outcomes. Is there can you directly draw a line between the two of these?
Yeah, I mean, think about just some of the wait times people have experienced listening to this. Those wait times in many cases are much longer than the 6 months we're talking about, that you have left to live.
You say there won't be a long wait time for this.
Yeah, well, and as a doctor, anyone who works in the NHS or has seen the NHS or has visited the NHS knows that doctors simply do not have time to go into detail in most cases. There are many shifts where you don't even have time for many hours to go and write up a painkiller for a patient just because things are that hectic. So the idea that you could go into someone's entire sort of back history, understand their personal relationships, the complex layered dynamics of coercion, the different sources of pressure, the financial situation, even if doctors were qualified to do this, which they're not really, the idea that they would have time to do it, especially in this NHS, is just completely crazy.
So decisions will be rushed.
Absolutely. I mean, yeah, there are far less sort of time-taking things that we don't have time for already in the NHS. The idea that we have time for this sort of thing is just absolutely bonkers. So this is why in the Netherlands, for example, they put in these sort of panels and things in place, and then eventually they just ignored them and doctors did their own thing.
Excuse me, sorry, so what?
So in the Netherlands, they had these panels.
Yes.
And obviously different sort of details. But in the end, the panels just sort of ticked the boxes, didn't do their full job. Doctors just did it without panel approval. And, if you read any book on how euthanasia progressed in the Netherlands, doctors just didn't have time for it. The panels didn't have time for it. The judges didn't have time for it. So they ended up just ignoring them and doing what they wanted to anyway. And then the legislator said, well, since they're doing this already, we might as well liberalize the law further.
Which is the slippery slope, which is the most concerning.
So the slippery slope doesn't just come through legislation. It comes through doctors saying, we don't have time to check all the boxes. We're just going to do it. And then the legislators say, well, if they're doing it already, doctors are good people. Let's just make it legal so they're not criminalized.
It's a very good point. Once you start to go down, once you cross a Rubicon, which is why the Hippocratic Oath and the Geneva documents and other documents are so important. They're the Rubicon that you're crossing. And historic, I mean, let's not forget, the Hippocratic Oath is 3,000, 2,500 years old, and has stood the test of time, therefore. Why has it stood the test of time? Well, because it is an ethical Rubicon. You cross it, and you're on the slippery slope. And when you're on the slippery slope, what happens is precisely what Calum has said. It all becomes too difficult. We can't do it. Oh, look, I haven't got time for this. Just tick the boxes. And that becomes part of the system. And then the system says, well, hang on. Look, we're already doing this. It's taking up far too much doctor's time. Why don't we just legalize the killing of patients anyway? And you go on and on and on in that way.
Well, when you look at the numbers in Canada, I believe it was around 1,500 people in the first year. And then last year it was up to 15,000-ish. And I've got it here. The track 2 non-terminal cases have increased from 2.5% in 2021 to 3.5% in 2022. Increased number of people who have just had mental health conditions. Then I also saw a case in Belgium where it was a child, so under 18, was the first case where they euthanized, or whatever you want to call it, a child under 18 for mental health issues, which to me is just bonkers. So on this podcast, you are definitely hearing me talk about Bitcoin a lot. Well, why? We live in a really strange time with governments driving inflation with their reckless spending and endless money printing. There is a way out of this. There is a way to protect your money, and that is by stacking Bitcoin. I've made loads of shows about Bitcoin. You can go and research this. You can go and read the books. But the truth is, it is the hardest money ever created. If you are interested in protecting your financial future, it's time for you to get on the Bitcoin train. I've been stacking Bitcoin personally and through my businesses since 2017. It's protected me, it's secured my family's future, and it also strengthens all of my businesses. So if you want to start stacking Bitcoin, where do you do it? Well, for me, it's with Gemini. They're a fully licensed, full reserve exchange and custodian, so they give you a secure way for you to buy and own your Bitcoin. There's no risks and no funny business. So if you're serious about stacking Bitcoin the right way, head over to Gemini.com, which is GEMINI.com.
In those places, Belgium and the Netherlands, we have seen people euthanized for anorexia.
What?
We have seen people euthanized for anorexia. We have seen newborn babies euthanized because they had spina bifida in the Netherlands. We have seen people criminals, convicted of capital crimes euthanized as basically capital punishment by the back door. We have seen people euthanized because they were transgender and they were unhappy at all their surgeries and everything, and they still felt horrible about everything, and so they were euthanized as well. We've seen in the Netherlands in particular many cases of involuntary euthanasia.
So it's not assisted dying, it's legalized suicide.
They've legalized murder in the Netherlands.
It rapidly becomes legalized murder because you've crossed that ethical Rubicon. And once you compromise the medical and nursing professions by not only allowing but forcing them, and if you allow, you end up forcing them into non-maleficence. You have crossed that ethical Rubicon, And that puts you on the slippery slope. The only way to guard yourself from being on the slippery slope is to step back from that ethical Rubicon. And we see it time and time and time again. We're seeing it in Canada. We're seeing it particularly in the Netherlands. We're seeing it in beginning to see it in Switzerland with this Dignitas clinic.
Well, another case in Belgium, there was a person, Tom Mortier, one of my wife's clients. In a way, she sort of represented some of his media work. His mother was euthanized without him even being told in advance. He just got a call one morning. The hospital said, "By the way, we've killed your mother."
What?
And that was taken, I think, to the European Court of Human Rights, saying this is, significant violation. I can't remember the exact sort of infringement they alleged, but he lost effectively. And so people will say, look, we know that, well, they won't put it this candidly, but they'll say, look, we know Canada is completely bonkers. We know the Netherlands and Belgium are completely bonkers.
Yeah.
This law is modeled on Oregon, which is much more sensible, much more strict and things. You look at Oregon, a tiny percentage, I think it was something like 3% had a psychiatric evaluation first. Something like 40% said one of the main reasons they were doing this was because they felt like a burden to other people. Significant percentage said they were doing it. I think about 8% said they were doing it for financial reasons. So this is the supposed strictest law in the world that hasn't had a slippery slope that we are basing it on. Even in that jurisdiction, there are horrendous abuses and violations of human rights and human dignity, horrendous abuses of the process. And that, I think, just goes to show that there is not a safe way of doing this.
Has anywhere tightened their laws?
Yes, in Australia, the Victorian Parliament purported to tighten or to have already a tightened law. In other states, they've now abandoned all those alleged safeguards on the basis that they're not really safeguards, and that's because they aren't. And I think the relevant health minister in the state of Victoria in Australia said, well, we're not going to change the law. No, we're happy with the way it is. And then more recently has said, well, actually, we are thinking of scrapping it altogether. Because it doesn't work. Because that once you cross that ethical Rubicon, you can't introduce safeguards. It's like trying to, I can't think of an analogy, but you're whizzing down the slippery slope. There are no brakes that are going to stop you.
Over here, 51-year-old Ontario woman chose MAID in 2022 after failing to find affordable housing free of chemical triggers to her condition. What?
Yeah. Down syndrome babies euthanized because they're Down syndrome. I mean, nowadays, Down syndrome, it's no big deal at all. You can be treated medically for Down syndrome so that you're never going to be completely normal, but you can lead a perfectly normal life.
We had a Down syndrome chap came into my cafe yesterday, came on board a Coke. We're having a chat with him. He'd just come from work. He swept at the hairdressers around the corner. Yeah. So, yeah, absolutely.
Yeah.
In Victoria and South Australia, health practitioners cannot initiate VAD conversations. In Western Australia, Tasmania, Queensland, and New South Wales, medical practitioners can bring up VAD. What's the V from the VAD?
VAD is voluntary.
But also discuss treatment and palliative care up to the same time. Ben White, Professor of Endo Life at Queensland University of Technology, say the laws in Victoria and SA,
South
Australia are a problem. Family members and patients describe not being able to find the right words, not being able to generate the right conversation. He says there's an issue of health literacy in voluntary assisted diet setting. How can you access voluntary assisted diet if you don't know existence? I mean, I just don't like the idea of a professor of end of life.
Look at that argument. What they're saying is, the only thing that really matters, it's got to be available. And if the doctors can't bring it up with you and say, this would be a good idea for you, that means there's no access to poisoning yourself. How shocking. They don't take into consideration that perhaps the better approach is, what can we do for this person to alleviate their suffering and to help them have a better life? And the answer is, kill them or help them kill themselves. I mean, what a counsel of despair.
Yeah.
And you can see from the other states of Australia that they're saying, well, we don't want that Victorian provision because, well, it might slow down access to being able to advise people to commit suicide. I mean, what sort of mentality is there that goes in that direction? Well, it's a mentality that is completely incompatible with traditional and therefore safe medical ethics. That's the problem.
But what you can see there is a sort of, they don't quite phrase it this way, but it's an appeal to sort of equity and equality of access. which when you have a society that is obsessed with these principles, as Western societies typically are, that is precisely why another reason the slippery slope is so inevitable. What he's effectively saying is there are some families who don't have the words to say, they might be less able to express themselves. And so we need to make sure that they have the same access as everyone else by providing for doctor-initiated conversations. Well, you can see how the same logic will apply, as with that argument, as with any other argument in contemporary politics, is why limit it to people with 6 months left? What about all these people who might not have access? What about people with this condition who might not have access? What about people with mental health? We shouldn't discriminate against them and stop them from having it. So it's absolutely abundantly clear that because the internal logic of the argument for euthanasia pushes the slippery slope, and all of the apparatus of equality legislation and equality sort of sentiments all drive in that direction.
And non-discrimination as well.
Can I ask about withdrawal of treatment? Do you see any difference between withdrawal of treatment and euthanasia?
There's a big difference, yes. Okay. And that's part of the problem, is that a lot of people... Firstly, I think James made a very good point at the very beginning where he said we're talking about assisted suicide, not assisted dying. Because, the other side will point to a lot of polls that say most people support assisted dying. And you ask them, what does assisted dying mean? And
speeding up the process.
The majority have no idea. They literally don't even know what they're supporting. And often they think it means withdrawing treatment that might be pointless or superfluous or horrendously burdensome. And that is already legal. So nowhere are doctors or healthcare professionals obliged to go at all costs to preserve life for as long as possible, even when doing that treatment is horrendously invasive or undignified.
And it would be bad
painful.
medicine anyway.
It would be bad medicine, and every doctor knows that they're not supposed to in every single case do chest compressions if the person is inevitably not going to survive them, and all you're going to do is crush a load of ribs and cause a lot of drama. Doctors know that you don't do that, and it's completely legal. What we're talking about here is something totally different, which is a doctor actively poisoning or giving the patient a medicine that will poison them.
Speeding up the process of death.
Deliberately. And even then,
shortening life.
They will say, well, we already do this through morphine, for example. They will say, look, if you give a patient morphine for pain control, it could lead to their life being shortened by causing respiratory depression, i.e. they start breathing more slowly and less, and then they stop breathing. And they say, well, if doctors are already doing that, what's the big deal about giving morphine directly to kill? Well, firstly, any good use of morphine does not do that. It's actually a widely spread myth that morphine typically leads to someone's life being shortened. If you practice palliative medicine properly, morphine does not kill people, even if you use a large amount for pain control. But the second thing is there is a very, very big difference between doing something that could end someone's life but is for a totally different purpose and may have a side effect of shortening their life, versus doing something that is specifically for the intention of ending someone's life. And we see this with, in the principles of war or any other kind of killing. Bombing a military target with perhaps a foreseen potential chance of a civilian dying is permissible in war. So, that's how war works. There are inevitably civilian casualties. That's very sad, but collateral damage is inevitable in most wars. Directly bombing a civilian target and intentionally bombing a civilian target is not only wrong, it's a war crime. So in every other area of life, we see that there's a very clear distinction between doing something foreseeing that something might happen and doing it with the intention of killing. And the same is true here, that is a huge difference. You are already allowed to do something that treats pain, that might, but in actual fact doesn't shorten life. What we're talking about here is directly, intentionally killing patients. And that is the Rubicon that we simply cannot cross.
But is there a chance that withdrawal of treatment is, in some cases, euthanasia by the back door? And I'm going to reference a specific case that you tweeted out. I'll try and pronounce her name. Sudichka Thiramarusha?
This might have been a while ago.
It was a 19-year-old with a rare mitochondrial disorder.
Yes.
Died in September 2023. What I remember about the case is that she was able to communicate. Mm-hmm. They showed the notes she'd written. It was a terminal condition, but she wanted to go to Canada for experimental treatment. But the doctors argued that because she didn't understand her prognosis, therefore she wasn't able to make. She was not cognizant. Mm-hmm. She wasn't mentally cognizant. That was obviously reversed in the appeal court. But should, in that scenario, if she wants to go and have treatment in Canada, why not? Why not?
Right.
That is the right to life, or the right to try and attempt to extend your life. The withdrawal of her treatments seems to me in some ways backdoor euthanasia.
Yeah, it's a very natural thought, and it's a very complex ethical debate, because in philosophical sort of thinking, the distinction between killing and sort of letting someone die is very controversial, and so that generates an incredibly load of difficult cases about, is something euthanasia? I think from a legal perspective, it's not the same, but you are right that there could be some cases where, by withdrawing some basic level of treatment that everyone has a sort of entitlement to, you are doing something tantamount to killing them. So, and I hate to invoke this because it's, most people are not Catholic. I'm not even Catholic. But the reason I mention this is because the Catholic Church has developed quite a useful framework for thinking about these issues, where they make a distinction between ordinary treatment and extraordinary treatment. Ordinary treatment is sort of basic things like food, nutrition, hydration, cheap drugs that have very little side effects but easily can save someone's life and that sort of thing. A sort of basic level of treatment that has minimal burdens but very significant, or minimal costs and burdens but very significant benefits. Extraordinary treatment might be something that has a very low chance of success, it's extremely expensive, it's extremely painful and invasive and undignifying for the patient. And you can imagine someone who wants to live reasonably saying, look, I'm sorry, it's just too burdensome for whatever reason. They say that ordinary treatment, that sort of basic level of food, nutrition, drugs, that sort of thing, even if the patient wants to pay for something themselves and do it, that is obligatory. You have to give that treatment. But if it's extraordinary, it's super expensive, it's highly burdensome, low chance of success, there's not an obligation to continue it.
But if you want to privately travel to another country, should you have that right?
I believe so, absolutely. As long as you haven't been misled about the prospect of success. So the reason I think those cases are difficult is not, you can make a case that they are so-called passive euthanasia, which means sort of letting someone die when you really should be keeping them alive. It's a more nebulous concept because it's about withdrawing treatment, which is more complex, but you could call it passive euthanasia. In my view, we've obviously seen many of these cases. Charlie Gard and Alfie Evans, two of the most sort of well-publicized ones. You can call these passive euthanasia, and you could say it's euthanasia in that sense by the back door, even though it's a different kind of euthanasia. I do think that they are highly problematic, especially since the patients have been raising their own money, or the families have been raising their own money, saying we are happy to pay to take the child to Italy and have them treated there. And so I see the outrage is totally understandable and the right thing, because I think, it's different if these families have been conned, they've been tricked and sold this treatment has a 90% chance of working, and they're raising money to go and do it, and they've actually been conned. I think there's obviously much bigger problems there. But if they know that this is experimental, they know that the chances are low, but the chances are not zero. It's a chance it could work. They have money, or they've raised the money to go and pay for it themselves. It seems to me that what you're doing by stopping them in such cases is you're basically condemning that child to death. So even if it's not actively killing the child, it's morally similar to that. I
also consider it similar to the option whereby when you die, you carry a donor card. Do you want your organs to be donated? If it's experimental treatment, it's a chance to learn. You might even say, look, I know it's low chance, but in going through the process, the medical professionals who are testing this on me may learn from this experience.
Right.
And so you would have a choice to become part of that experiment as part of your death. A noble cause, but
yeah. Well, exactly. Not? Yeah. You could become even. Yeah, I think that's absolutely right. I think you can't force the state to pay for a treatment that's going to cost £10 million a year. I think that, and everyone agrees with that.
Yeah.
And people should be properly informed. But if you are willing to pay for it yourself, or if it's a very cheap treatment that the state could easily administer and would be totally normal for anyone else, then I think you can expect that the state would allow you to do that.
I found that mental capacity assessment that they made troubling in that they said because she disagreed with her prognosis and wanted to try alternative treatment, that she therefore lacked the capacity to make the decision, which is strange. That feels coercive.
It is.
Because you're saying, I have to agree with you.
That was the ST decision. A friend of mine, colleague of mine, in fact, Bruno Quintovale, who's another barrister, was in that case. He was also in Takiba Rashid's case, and I think in Alfie Evans' case. And in both of those cases, except that he succeeded in Takiba Rashid, if that's how you pronounce her name, he by going to a different court than the usual court, he was very clever about the way he did it, and she was allowed to go abroad to India I think it was India, to have treatment. But in Alfie Evans and in the ST case, they weren't. Well, this is plainly coercive on the part of the state, and judges are the state in a judicial capacity, preventing the family from taking their daughter, or from the daughter herself wanting on her own initiative to go and try an experimental treatment, which, as you say, might work. And if it works, it benefits the whole of humanity. And here we have British judges, and by the way, British judges are among the worst when it comes to this sort of thing, saying, no, sorry, you can't go. I mean, this is tyrannical. But that's what happened. Here's what the judge said in the ST case. I'm not sure what the position is as regards, there was a reporting restrictions order on it, so I won't mention the.
Well, because the family felt like
name.
they couldn't even appeal themselves to the in the media because they would break their own reporting.
No, because they would break the report. I don't know if the reporting restrictions order is still in place. By the way, in two other cases, Abbasi and Holstrup, there were reporting restrictions in place, and the case is seemingly open-ended. And again, it was. Bruno Quintovale took it to the Supreme Court and won. Supreme Court said no. Principle of open justice, we can't have open-ended reporting restrictions forever, and those two cases can now be reported on. So arguably, if the principle applies equally in the ST case, then in the ST case, the media can discuss it, but erring on the side of caution, I'll simply continue to call it the ST case. Yeah. But what can be quoted is what is in the open judgment, which is reported. And Mrs. Justice Roberts said this, I find on the balance of probabilities that ST's complete inability to accept the medical reality of her position. I pause there to say what the judge means there is what she's been told by the doctors. And as I said earlier in relation to prognosis and diagnosis, the doctors could be wrong. They often are. No criticism of doctors. That's just the nature of healthcare and medicine. Or to contemplate the possibility that her doctors, plural, may be giving her accurate information, well, it might also be inaccurate, is likely to be the result of an impairment of or a disturbance in the functioning of her mind or brain. Well, it might not be. It is not necessary for me to seek to further define the nature of that impairment. Well, sorry, if you're going to say her mind's impaired, you need to say how and why. I am satisfied that it exists, period, and that it operates so as to render her unable to make a decision for herself in relation to her future medical treatment. So, she doesn't listen to her doctors, she doesn't believe her doctors. Her doctors have said she thinks they may be giving her inaccurate information, both of which might be true. Therefore, she's got an impairment of the brain. All right, well, what is this impairment of the brain that causes her to say, well, sorry, doctor, I'm not sure I agree with you. There's this treatment in Canada and I'd like to have the benefit of it. How is that an impairment of the balance of your mind such that she doesn't know what she's saying? And if it is, could you please tell us what type of impairment? No, says I don't need to. The mere fact that she disagrees with her doctors, who are undoubtedly giving her accurate information, means she's nuts.
Well, I think you're right. Go. It's tyrannical.
I mean, it's absolutely appalling.
I don't think you have to be a sort of, a sort of conspiracy theorist to think that doctors could well be wrong in these cases. I think this is the exact area where doctors are most clueless, which is in terms of highly specialized sort of experimental treatments. Most doctors are not up to date with what is possibly going on in other areas of the world. They know almost nothing about ethics and the sort of values involved that patients might be using to make their decisions about whether their life is worth living. They know very little about consciousness and how quality of life is connected to consciousness and abilities and so on. Just as one example, I can't remember which case it was, but in one of these situations in previous years, the judge said both that the patient was unconscious, so she had no quality of life because she couldn't experience anything positive. And at the same time, she was in insufferable pain, and therefore it was in her best interests to put her down or euthanize her, effectively. So it's saying you cannot feel anything positive because you cannot feel anything at all, but you're feeling so much pain that we have to kill you or let you die. And those are obviously completely contradictory, but it formed the basis of the legal judgment. So I think with the doctor's side, what I would say is, I have seen so many times, doctors do not understand that people understand quality of life and the value of life in a variety of ways. Yeah. Doctors have been indoctrinated with this idea, partly because some of the medical teaching on it, that quality of life means basically a utilitarian calculus, what you're able to do, how profitable and constructive you are. If you can walk and talk, you have a good quality of life. If you don't, you're basically useless. And so they genuinely believe, not everyone obviously, but many, many doctors genuinely believe that quality of life is an objective measure that is determined by someone's abilities. And that therefore, if someone is severely disabled, they objectively and factually have a low quality of life, and therefore there should be a lower threshold for ending their lives or letting them die or killing them. I've seen that time and time again. I've seen DNAR forms, do not resuscitate forms, where the main reason for not resuscitating someone was simply that they had Down syndrome. And when you have seen this in practice again and again and again, and you have seen doctors explicitly articulate this idea, you realize that letting them kill patients is a bad idea, because they are going to say objectively, and this gets put into the medical judgment. So the judge in that case is probably not just thinking about the empirical data of, what are the chances of recovery? What are the chances of being able to walk again? The judge is probably looking at what the doctors have said, which implicitly has so many crazy ethical judgments about what quality of life is being treated as a medical fact. They probably think that the doctors have said, this person has a low quality of life in our sort of subjective opinion and our value system, and this is a genuine factual medical opinion. And that's a big worry, and that's another part of why this legislation is so dangerous, because doctors will say, this person objectively, medically has a low quality of life. You can dispute the medical facts all you want, but these are the medical facts. This person has a life that is not worth living. And the judge is going to say, well, I'm not medically qualified to judge on medicine. So I guess it's factually true that this person has a life that's not worth living, and I can't possibly decide. The patient can't disagree because the doctors have said so. And therefore, sorry, you don't have a life that's worth living, and off you go.
That's awful.
It's
not only that, but you've also got a situation. I mean, the law as it stands at the moment, I can't remember their case. I think it was the Wiltshire case, and it went to. Did it go to the Supreme Court? I can't remember, but it certainly relied on a dictum of the Supreme Court. It says that if the patient does not want a DNA CPR order, then you can't impose it on them. That happens all the time. And one of the problems with these types of cases, and particularly this bill, is that the principal person who could give evidence against the doctors or nurses who are disobeying the law is dead. Can't come back and give evidence. That's why it's so very, very important to ensure that we get the law right in relation to end-of-life care. Because if we don't, the principal witness won't be able to come back and tell us how we got it wrong, because they're dead. And yet, as Calum says, we get DNA CPR orders all the time, frequently contrary to the family or even the patient themselves' wishes. And in that particular case, the judges, I can't remember which way they went, but effectively the position was that if what the parent or what the family say represents the patient's wishes, it's got to be respected, and you don't put a DNA CPR order up. But it happens all the time. Sadly.
People believe this reasoning when you talk about capital punishment. They say, if one innocent person gets killed by the death penalty, then we shouldn't have it. That's too big a risk to take. Yeah. Well, this isn't just a theoretical risk.
We used to say one of the importance of having a jury is that if the jury decides to let 10 guilty people off, that's better than convicting one innocent person. That's how we used to view it. But you will notice, I regard this as a sinister development, there is a move afoot in government circles and indeed wider circles to restrict the number of cases where a jury will be involved, or to restrict the number of lay magistrates. And yet,
what's a lay magistrate?
They now call them district judges (brackets criminal), but what the ordinary man in the streets calls a magistrate is not a lawyer. Is a layperson, and they are guided in the law by a court clerk. But they do have some professional lawyers who are district judges, criminal district judges. And the reason why it's important is simply this. If a particular piece of law is an ass, hence the expression the law is an ass, a non-lawyer can say the law is an ass, we're not going to find you guilty. A professional judge can't do that. He must uphold the law because that is what he's bound to do as a lawyer who has promised so to do. Likewise, a jury. A jury can say, well, the judge has told us that this chap's guilty and that we should find him guilty. We don't agree. And even if the jury's wrong, no court in the land can inquire into what goes on in a jury room. Now, of course, the downside of that is they can't inquire if there's been an unfair conviction. But the nature of the jury system is it is a safety valve for stupid laws and stupid judicial decisions. And I was in a case long time ago when I was a new barrister in which a piece of rather hasty legislation, not anything like as bad or hasty as this assisted suicide bill, called the Protection of Military Remains Act. I was in the armed forces myself before I came to the bar. And it meant that you had to get a license from the Air Ministry before you could dig up military remains, particularly World War II aircraft, Spitfires and so on, that had crash-landed. This chap dug up a Spitfire that had crash-landed near Chilham Castle in Kent. He got permission of the landowner, permission of the family, but not a license from the Air Ministry. So I had to tell him, well, you've got to plead guilty because you've told me so, but we can mitigate. And because it was a lay bench, I was allowed to mitigate for a whole hour with the newspapers in the back of the court. If it had been what in those days was called a stipendiary magistrate, nowadays called district judge, I'm sure he would have given me no more than 2 minutes maximum to mitigate. And I had a whole series of very interesting examples and what his father had done, what the chief constable had done, what the fact that the coroner was not involved, and so on and so on and so forth. Well, after 10 minutes, out came the lay magistrates, and not only did they give him a discharge, but it was an absolute discharge. In other words, they're saying, you're guilty, but it's a stupid law, and we're not going to punish you. Lay magistrates can do that. Juries can say, not guilty, whatever the judge may say, but professionals cannot do that. This is a safety valve. It gives you an example. If you're trying to get rid of that safety valve, what are you saying about the future of the law in this country? Likewise, the background to this particular bill is what we've just been discussing. First of all, the practice in the NHS, what's actually happening, DNA CPR orders, the fact that effective euthanasia is taking place, and then coupled with very controversial and very, I would say, unpopular decisions by the judges, is a background to this legislation, which is a very unhealthy background. One of the things that's happening I don't know if Calum agrees with me on this, but I see it again and again and again in medical cases that come to my attention and come across my desk, is that the favoured way of shortening a life, let's put it that way, rather than putting it any more controversially, is to use, in combination, morphine and midazolam. Midazolam is a sedative, and morphine is an opiate. Or morphine is used to eliminate pain, and midazolam is used to sedate you, ostensibly to calm you down. The combination of the two is a very effective way of shortening somebody's life. And what happens is the doses go up and up and up. Patient dies, and nobody really knows, did he die from dehydration? Did he die from malnutrition? Did he die from his underlying condition? Or did he die from having an increased dose of morphine and midazolam? And and because this is why I said earlier, if you want to kill somebody, get a doctor or a nurse to do it, because it's very, very difficult to pin the blame on them. And the use of morphine and midazolam as a regular feature of treatment of the terminally ill, of the sick, of the chronically sick and elderly in the NHS is now very common. I myself, with my own mother, when I went down to visit her in hospital, I said to the doctor, "Can I have a look at the drug chart?" And the consultant said, "Well, why do you want to do it?" "I just would like to see it, if you don't mind." Sure enough, she was being given morphine and midazolam. And I had earlier said to the doctor, is she in pain? "No, she's not." "Well, is she thrashing about, or is she in any way requiring a sedative?" "No." And then when I went to the drug chart, there's morphine and midazolam.
Well, that sounds like malpractice.
Well, it does, but it's very easy to get around that. It's very easy for a doctor to say, "Well, we wanted to make sure she was comfortable. We wanted to make sure that she wasn't agitated, so we gave her midazolam." And whilst she wasn't actually in any pain, she might well have been. So
They just need a bed.
in order prognostically and proleptically to ensure that she doesn't suffer pain, we've given her a small dose of morphine, and the morphine and the midazolam goes up and up and up. And then I got a phone call as I was going down to visit her. "Oh, hello, Mr. Bogle. Sorry to have to tell you about your mother." And I said, "Well, what is the problem?" "Well, I'm afraid she's passed away." Well, I wasn't there. My brothers weren't there. I don't know exactly what happened. And this is a situation that happens across the country every day, dozens of times. And people are simply told, "Well, I'm afraid she's passed away." And we don't know.
Yeah.
Now, there was no identifiable condition that my mother was suffering from. She was just 85.
Right.
"Sorry, you've had your time.
We need
We need the bed space.
Yeah.
Just up the dose a bit." And this happens again and again and again and again. That's the background to a bill like this.
Yeah.
It's not about choice. It's not about autonomy. It's about problems in the NHS with finance and bed spaces. And the way to solve that is not to kill people.
It's very important that you don't lose this, okay? This is your inheritance through Bitcoin.
Let Bitcoin rip. Don't rip up your Bitcoin. Set up inheritance with Casa.
I do want to discuss the changes to the abortion bill as well. Just before I do, is there anything else either you want to say on this?
I do, if I may.
Yeah,
Sorry
please.
to
No, please
dominate
do.
the conversation. Going back to the coroner, even at the euthanasia clinic Dignitas in Switzerland, every death has to be referred to the state procureur, that's the state prosecutor, to check that the correct prescription was issued and that consent was properly and fully obtained. There's no such provision in this bill, nor has the matter been given any proper thought by the proposers of the bill. In all jurisdictions in the UK, all deaths involving a medicinal product or substance or self-harm or neglect, including self-neglect, a treatment or a procedure of a medical or similar nature where there has been a death from adverse reactions or from prescribing errors, must, as a matter of law, be reported to the coroner. The coroner may or may not hold an inquest, but it must be reported as a matter of law. And it's by no means clear that this will be the case after an assisted death under this bill. Indeed, Kim Ledbetter has said the coroner does not need to be involved, and that wasn't voted down. And I gave the example of where a baby after an abortion lives for a while and then dies. But there are a stack of other questions that have not been answered. What will be the scope of the function of the panel? To what extent will it be expected to exercise discretion? The answer at the moment is none. Or is it the panel's role only to certify that the boxes have been ticked? Yes, at the moment. Who can apply to the panel? And who can and should be joined as parties? Don't know. Are there to be reporting restrictions? Are the identities of any of the participants, in particular the patient, the witnesses, and the countersigning documents, to be anonymised? And by the way, the witnesses will only be witnesses, which is essentially the doctor, to the box ticking, not to consent. What procedures are to be adopted for testing and, if need be, challenging the evidence? At the moment, none. There will be no way of challenging the evidence. Who should exercise that function? Well, there is no function to exercise, so the answer is nobody. Is there to be an independent evidential investigation? No. If so, who would undertake it and who would pay for it? Answer, not going to happen. Should the panel be required to publish their written reasons? Nope. How are appeals to be incorporated? And why is there currently only provision for appeal if there's a refusal by the panel? Does the conscience clause apply to the panel members? Answer, no. Why should a KC, a psychiatrist, and a social worker necessarily be adequate as members of the panel? What makes them qualified to decide that somebody has genuinely consented to suicide? Or indeed whether it's appropriate in those circumstances? What are the risks if evidence from the applicant can be exceptionally waived or be pre-recorded? How can it be adequate that the panel need not ask questions, make any further inquiries, or notify anyone at its discretion, and need only hear evidence from one doctor? What about open justice? If the panel can sit in private, which it can. And why has the panel no investigatory powers? Why can it not authorize, say, the police or a particular public body to go and investigate? Why is there no requirement to give evidence on oath? And why can the voluntary assisted dying commissioner only consider applications refused by the panel? He can't consider where there's an objection by the family, and the family have no right to object or appeal anyway. Can I just, and a conscious...
Well, it just sounds badly thought through,
Absolutely.
rushed.
Absolutely. But let me just, if I may, take up a little bit of time, because I think this is really important and goes to the hub of the issue.
Yeah.
Raised by the proponents of the bill as much as by anybody else. And that is the vulnerability of the position where people are vulnerable. And in the case of Nicholson, this is what Lord Sumption said, and forgive me for quoting from him, but he puts it very well. The vulnerability to pressure of the old or terminally ill is a formidable problem. The problem is not that people may decide to kill themselves who are not fully competent mentally. I'm prepared to accept that mental competence is capable of objective assessment by health professionals. The real difficulty is that even the mentally competent may have reasons for deciding to kill themselves, which reflect either overt pressure upon them by others, or their own assumptions about what others may think or expect. The difficulty is particularly acute in the case of what the Commission on Assisted Dying called indirect social pressure. This refers to the problems arising from the low self-esteem of many old or severely ill and dependent people, combined with the spontaneous and negative perceptions of patients about the views of those around them. The great majority of people contemplating suicide for health-related reasons are likely to be acutely conscious that their disabilities make them dependent on others. These disabilities may arise from illness or injury, or indeed a much larger category from the advancing infirmity of old age. People in that position are vulnerable. They're often afraid their lives may become a burden. Their fear may be the result of overt pressure, but may equally arise from a spontaneous tendency to place a low value on their own lives and assume that others do so too. Their feelings of uselessness are likely to be accentuated in those who were once highly active and engaged with those around them, for whom the contrast between now and then must be particularly painful. He then goes on to say, the legalization of assisted suicide would be followed by its progressive normalization, at any rate among the very old or very ill, in a world where suicide was regarded as just another optional end-of-life choice. The pressures which I have described are likely to become more powerful. It is one thing to assess someone's mental ability to form a judgment, but another to discuss their true reasons for the decision which they have made and to assess the quality of those reasons. I very much doubt whether it is possible in the generality of cases, but to distinguish between those who have spontaneously formed the desire to kill themselves and those who have done so in response to real or imagined pressure for the impact of their disabilities on other people. There's a good deal of evidence that this problem exists, that it's significant, that it is aggravated by negative modern attitudes to old age and sickness-related disability. This is a Supreme Court judge in a particular case, and the Divisional Court in the Conway case said something very similar, making reference, in fact, to Lord Falconer's bill about the feelings of people in those circumstances. And of course, as I said earlier, you've also got people who are affected by drugs, affected by alcohol, affected by malnutrition, affected by depression, affected by other illnesses, but just a person with no other specific illness than old age is already a vulnerable position as regards this bill. No provision for protection for them whatsoever in this bill. And what is quite extraordinary is the way the promoters of the bill, and apparently the government as well, are quite happy completely to ignore these very wise words from one of the most senior judges in our country, Lord Sumption, who's now retired, in our most senior court, the Supreme Court, as well as from bodies like the Royal College of Psychiatrists and the Royal College of Pathologists, not to mention a whole range of charities that deal with people who are in those circumstances. They've just ignored them. And yet, as I said earlier, these are members of Parliament who are new to Parliament and who have no involvement and no experience in the vast majority of cases with end-of-life care whatsoever. It's a rotten bill.
Well, it just highlights how weak government is at the moment. Yeah. I mean, we have a huge amount of dissatisfaction with government at the moment, low voter turnout, voter apathy. People are generally pissed off with the major two parties of, old major parties, Conservative and Labour. I think it reflects a general weakness that we have with MPs. We just don't have particularly wise or a strong calibre of MPs. I think that reflects that. I mean,
the fact that 160 Labour backbenchers were against it so that the government only had a majority of 23, doesn't that ring a few alarm bells for the Prime Minister and for the relevant ministers? Doesn't it ring a few alarm bells for the promoters of the bill? It just shows that there is an increasing development of a mentality which absolutely underscores the slippery slope argument once you cross that ethical Rubicon.
So, yeah.
It very rapidly becomes accepted, not just in the medical profession, the nursing profession, but among other professionals. Oh, well, this is now normal these days. And then you are on a very, very dangerous slippery slope. And I recommend to your viewers and listeners two books which highlight what has happened in the past. One is called A German Warning to the World by Bernhard Schreiber, and the other one is called Death and Deliverance, or Deliverance and Death by, who was it by?
Well, we can find it. We'll put it in the show notes.
It'll come to me.
Yeah.
Both of which show what has happened in the past, and in particular some very obvious examples, which I'm sure I don't need to underscore. And how very quickly the slippery slope affected the medical profession and the nursing profession, so that they became accustomed, indeed more than accustomed, to this kind of more and more casual approach to the importance of human life, at whatever stage of development that human life may be at. And after the Second World War, the reason why a lot of these medical protocols were put in place, in particular, of course, the United Nations Declaration of Human Rights and later the European Convention on Human Rights, was precisely to say, well, hang on a minute, how did these horrible things happen? We've got to put in place a very clear international framework that we mustn't depart from. We are now departing from them. Now, where is that going to go? Now, I'm not suggesting it's going to go down the route that it went down in between the wars, but the historical evidence is whatever route it goes down is not going to be a good one for the average citizen in our country. And the protection of our rights, in particular our primary right, which is Article 2 under the European Convention of Human Rights, the right to life, may end up being severely and seriously compromised. And if you don't have the right to life, all those other rights are not going to be much use to you.
Yeah, I do, conscious of time, I do want to at least touch on the changes to the abortion legislation because, as you said, that came through very quickly. I didn't even realise it was being debated, and before I knew it, the legislation had changed. My understanding is the decriminalisation for women who self-administer abortions after 24 weeks. Is that broadly correct?
Yeah. In fact, I remember the name, Michael Burley,
okay.
Death or Deliverance.
We'll put that in the show notes.
Death and Deliverance.
I'm going to, sorry to do this, but I'm going to put this to you first, James, just because we spoke but I want to know James' view first. Where does life begin, and when, and who should decide, and is this a moral question or is this a healthcare issue with abortion?
Well, it's a combination of things, isn't it? I mean, I have my own views, other people have their views, but I don't think anybody is in any doubt that a day before a child is born, it's a human being. Because the very next day the child is born and it's a fully formed child. And the day before it is born, it is every bit as much a fully formed child, and nobody is going to dispute that. Not even those who voted for abortion right up to birth are now any longer going to dispute that. Once upon a time, the debate was, oh, well, it's just a clump of cells, it's not a human being. It's going to become a human being, but isn't one yet. Well, I mean, I don't know about you, but I've never seen a clump of cells turn into a human being that didn't essentially have all the relevant characteristics that will result in it being a human being. But nevertheless, leaving that argument aside, there is no dispute whatsoever that when a child is about a day or two away from being born, it is a fully formed child. It's a human being. So the debate has now shifted from it's a clump of cells to, yes, it's a human being, but so what? Nowadays, if a human being is inconvenient, we kill them. Now, think about that for a moment.
Well, I'm sure, Calum, you've got very strong views on this.
I have some views on this.
Yeah.
Notoriously. I think James is right. Most people in this country are pro-choice, but most people in this country do not support abortion the moment before birth. And typically the response is, look, if someone's having an abortion at that stage, they're so desperate, it's probably a medical emergency. Some people even say explicitly it's always a medical emergency. It's the only reason people would ever have an abortion that late. Factually, this is just simply false. We have clear examples. After about 20...
Well, let's give one so people understand, because I read the case of a woman at 39 weeks had an abortion to hide an affair.
Yeah, exactly. So that was Sarah Katz. This was in 2010. Sarah Katz was 39 weeks pregnant, not even, 8 months. She was literally at full term. The baby was fully, could have been born at any moment and it wouldn't have even had any health problems or anything like that. Full term baby. She had a 7-year affair from her husband and wanted the baby not to be there as a result. And so she had an abortion by herself at 39 weeks. The judge, we have the sentencing remarks. The judge says you showed no signs of remorse. There are no mitigating factors. It wasn't like she had some abusive background or threat of honor killings or whatever it might be in the background. 0 mitigating factors, 0 remorse for killing a baby at 39 weeks. Now, most people in this country, no matter how sympathetic they might feel towards women who are pregnant and have abortions, and even if they think most of the blame is the abortion provider typically, and they want to protect women, the reality is that most pro-choice people in this country think that Sarah Katz should be in jail. I think Sarah Katz should be in jail. I think if you kill a baby at 39 weeks of pregnancy to hide an affair, you have no remorse, no mitigating factors, you should be in jail for a long time. And the majority of the country, according to surveys, agrees with that.
Because if it happened post-delivery of the baby,
it would be
at
murder.
38 weeks,
Yeah,
it would be murder.
For a less developed baby, it would be murder. Yeah. So for me, this is clear cut, and I think it's an example of where this government is just totally out of touch with public opinion. And you can kind of understand why, because for many years, they have been able to push much further than public opinion. So the general public in this country did not think that we should have pills by post, where you can just send abortion pills in the mail from the clinic and have the woman have an abortion at home. Most people thought that was dangerous. The general public, likewise in surveys, think that the abortion limit should be reduced from 24 weeks to something more like 12 or 16 weeks. And the European average is 12 weeks. So the general public already think that the abortion law in this country is too liberal and needs to be, they don't think it should be banned, but they think it should be more tightened. But for years, the government, including the Conservative government, have gone in the opposite direction and gotten away with it because it hasn't been that well publicized. There's been a lot of spin.
But why? If it's not popular, it starts to feel like a death cult.
I mean, it is. Yeah. And why are they pushing it, you mean?
Yeah.
They're extremists. I think, even when you speak to people who do abortions behind the scenes, often a lot of them will say, I won't do an abortion beyond 16 weeks or 20 weeks because I think it's, these are people who do abortions. Even a lot of them say there should be limits. But the problem is, for the radicals, they just think that if it's a woman's body, it's a woman's choice. The child does not matter at all, because if you say that the child could matter, then they have to answer difficult questions about when does it matter
Yes.
and how does that balance with abortion earlier in pregnancy. So for them, the only feasible possibility is that we have to just completely erase the child, because once you admit that there is ever a child in pregnancy, you begin to have difficult questions about where should you draw the line, what should the implications be, and that sort of thing. And those are difficult questions for them to answer, because scientifically, the only real answer to when life begins is at fertilization. That's just the scientific facts of it. And so they don't want to open those conversations about what is the child, when does the life begin, because it will inevitably cause problems.
Well, even the heartbeat law in Texas was very challenging.
Right.
And that is not even a fertilization. But even at 24 weeks, despite my disagreement with it, my personal views, that at least felt like something.
Right. And I think what they thought, I think they genuinely overshot and didn't realize the backlash. I think they thought, we can frame this as, look, we're not legalizing it fully up to birth so that doctors could do an abortion at 39 weeks. We're just saying in those desperate situations, women should not be in jail. And so they're sort of appealing to our compassion for women and saying, well, it's not about when abortion should be legal, it's about should a woman go to jail. And I think they didn't expect people to turn around and say, well, actually, yeah, if a woman has an abortion at 39 weeks for no good reason, she should be in jail.
What did happen to her?
She got a sentence of 8 years.
Wow.
Which is pretty substantive.
Yeah.
And there was a similar case a year or two ago with it was 2 years ago, Carla Foster, who had an abortion at 8 weeks. Again, no medical reason. The baby was perfectly healthy. Wasn't sort of a extreme situation, but she had an abortion at 8 weeks. At 8 months.
Sorry, yeah.
And she got given a sentence, a custodial sentence, which was then sort of revoked. I think the appellate court got rid of the sentence, basically, or at least got rid of the custodial sentence. But again, in that case, there was polling that clearly showed the large majority said that the sentence she was given, which I think was several years, was either about right or too lenient. The majority of people said she should be in jail for at least that long, maybe longer.
Well, yeah, it's got it here. Only 65% supported abortion on demand before 24 weeks. Only 17% are after. I assume the difference is people who just don't want to answer. In 2022, 88% occurred. Oh, this is the ones that actually did happen. Outside of this change to legislation, James, what rights does a fetus or a baby within a pregnancy have?
Well, with this legislation, none.
What did it have previously?
Previously, although the law recognizes that a fetus exists because, for example, in the law of accumulations, is the time period which is a life in being plus 21 years includes a life en ventre sa mère, as the law French has it, meaning in the womb of the mother. But as far as having human rights is concerned, it's a very dubious situation. Does a fetus have any rights at all? Arguably not. Certainly not now. But the mother has rights, and you would have thought the father would have rights, but the father has virtually no rights either, even if married to the mother. And the difficulty is, say, take the case of Carla Foster, for example. I think she was given a 28th-month sentence, reduced to 14 months and then suspended by the appeal court, criminal division. The judge concerned, Mr. Justice Pepperell, Edward Pepperell, was subsequently heavily criticised by campaigners. But, it's a jolly unfair criticism of him because he was simply applying the law, and that's what judges have got to do. They can't just apply their own personal opinions. And he did so. And the Court of Appeal didn't criticise him for that. The Court of Appeal with Victoria Sharp sitting with, I think, Lord Justice Holroyd and Mr. Justice Lambert, I think, they said, it's a very sad case and it calls for compassion, not punishment, and so on and so forth, and therefore reduced her sentence. But they didn't say, you're not guilty. They didn't overturn the conviction. That's if there was an appeal against conviction. And the situation, I mean, I entirely agree and see what Calum is saying, but conversely, what if you're an ordinary person, ordinary woman, you're pregnant and you're in a desperate situation and you don't know what the law is, and you reading the newspapers as everybody does and listening to the media and you're affected by the climate, the moral climate. Once we have crossed that ethical Rubicon, you can see how they might say, well, what's the difference if I'd done it, 8 weeks earlier to now? I mean, I know as a human being, I can feel as a human being, or perhaps they don't even think that far. But once you've got a climate of opinion, particularly among professionals, that it's all right to kill people in certain circumstances, well, why shouldn't she will argue, why shouldn't she do so when it's a little bit beyond the limit? Well, the answer is because it's against the law. But the law is a bit of an ass, isn't it? Because the law is saying it's all right one day before, but not one day afterwards. How can it be? It just ethically and morally and logically doesn't make any kind of sense. So once again, we're on an ethical slippery slope. And if some people are slipping further down the slope than others, it's a little bit hypocritical of the system to say, well, I'm going to let you off, but I'm going to drop 10 tons of bricks on you. You're going to prison for 10 years. Of course, people are going to say, well, hang on a minute, that's a bit unfair. But interestingly, from what you and Calum have said, the general public didn't say that. They said, well, hang on a minute, this is a human life. And it's quite obviously human life, and it's against the law, and this is a killing. We've got to punish it.
And is it any scenario that a woman, late-term pregnancy, makes a decision to self-administer abortion, there's no scenario where they will face criminal action?
No, even if it's just because the baby's a girl. So if a woman says, I wanted a baby boy, or my family wants a baby boy, I don't want a baby girl, they give an abortion at 9 months, there will be no penalty at all.
Apart from the intrinsic stupidity of such a law, and injustice of it and illogicality of it, people haven't thought through the consequences. Once again, it is adding to the moral climate within the health service that less and less values human life and makes it more and more dependent upon values other than the mere fact that it's a human life. And those other values are quality of life. I don't know if you've heard of a chap called Professor Peter Singer. He's an Australian who now is a professor of philosophy at Princeton, I think. But he devised a sort of calculus supporting exactly what Calum was saying, that people think you can now measure, or at least almost quantitatively, the value of somebody's life. Of course you can't. It's a purely subjective decision. And he devised a concept called QOLY, QOLY, quality of life years. How many quality of life years do you have? And if the answer is you've got 10, well, after the 10 years are over, well, you should be disposed of. Not you may go and commit suicide, but be disposed of. In other words, the state should get rid of you. Well, we're nowhere near that, thank goodness. But the mere fact that it's being discussed by a professor of that sort of standing at Princeton University shows you just how far, to put it in political terms, the Overton window has moved. Let's call it a moral Overton window. Now, the further that moral Overton window goes over the edge of the slippery slope, the more likely it is to go down the whole way. And what is at the bottom of that slippery slope, heaven alone knows. And but we have seen from historical precedents, it ain't good.
It does start to feel like a death cult. Just we have MPs voting on things that should feel abhorrent.
Yeah.
But it's normalizing it.
It is.
Which is...
And we've also got to remember we don't need to do this.
Yeah.
As long as you say, well, look, this is a human life. Article 2 of the Convention protects human life. Please protect human life. Doesn't matter what stage it's at, whether it's, you've only got 3 hours to live, we still protect human life. Doesn't mean to say, and Calum is absolutely right on this, that we do everything in our power to prevent that person from dying, jump up and down on their chest, break their ribs, just to keep them alive. Obviously, that's bad medicine. We should allow people to die naturally. And in so many of these cases, if you just wait another couple of weeks, they will have died and died naturally. You don't need to kill them today in order to get 2 weeks' worth of bed space. But that's the sort of situation we're getting into. The bottom line is you've got to protect human life. And putting it more simply, don't kill people.
Yeah.
Don't deliberately kill people. And Calum was absolutely right that the way the law looks at these particular homicide issues and suicide issues as well to a certain extent is a spectrum from full intentionality to accident. And in between you have negligence, recklessness, and intentionality. So, for example, if you have full intentionality and when you kill somebody, that's murder and you'll be convicted of murder. But if you are reckless or negligent, then you will be convicted of manslaughter and the penalty will be considerably less. If, on the other hand, it was simply an accident, there'll be no penalty at all. So you see the spectrum of the engagement of the will determines what the quality and nature of the offence is, and therefore what the punishment should be, and the extent to which it is wrong and should be punished by society. Now, once you meddle with that, and once you say certain types of intentional killing are going to be perfectly all right, you get into moral and ethical confusion so that ordinary people like Carla Foster think, well, I know it's a human life, but listen, you kill human life in other circumstances. Why can't I? I don't want this baby. It's a result of an affair. And you can start to see, well, how can you really blame this person? I mean, you have to for the sake of the law, but you can see you have society itself has created the very problem that it now wishes to punish. Don't go down that route in the first place is the answer. Obey the law and the conventions that were put in place to protect human life, the United Nations Declaration of Human Rights and the European Declaration of Human Rights, Article 2, right to life, protect human life, and then you won't face these problems. Conversely, you will have alternative solutions will be found for a mother who is pregnant and doesn't want the child. Much better developed adoption services, which are at a low ebb in this country, and likewise proper palliative care for people in the latter stages of life or latter stages of an illness will be much more developed. If you say, let's just kill them, you will not develop those services. You will not provide the services, which can very easily and readily be provided and not that expensively nowadays with the modern medicine and technology that we have. Instead, you will simply be compromising a moral principle which will leave you in a state of moral confusion, the end of which you do not know. And that's why we don't want to go down that route. And we now have gone a considerable way down that route with the result that all of these problems are beginning to spring up. And we're going to get more and more legislation of this kind, rotten, lousy, ill thought out, ill debated, legislation produced by people who don't know what they're talking about, that will create even more problems, and that will result in the need for further legislation, which might also be rotten, lousy, ill thought out, and so on, and so on, and so on, with consequences that we cannot yet predict. The simple answer is, don't cross that ethical Rubicon, and then you won't have the problem. There's another dark consequences people haven't thought about. A lot of people are up in arms in this country about the extent of legal and illegal immigration. Well, sorry, if you're going to discourage people who live in this country, citizens of this country, from having children, and there are a lot of discouragements in the law, which we haven't got time to go into now, but believe me, there are many,
I understand.
Many financial, taxation, the family law system, and so on and so on and so forth. And at the same time, allow abortion up to birth so that, it's a girl, I didn't want a girl, get rid of her. Then you cannot complain about the fact that you're not having children and somebody else will. They're going to come in and they're going to replace you and they're going to have children. And you can't complain about that unless you're prepared to perpetuate your own people. Well, it's going to follow as night follows day. I appreciate that's not
I
the
understand.
primary moral and ethical argument.
But it's what we spoke about before we started. I am just conscious of time, though, as well. And we could probably discuss this for hours. But we discussed that beforehand in that we have a population issue. And we're terminating, 250,000 pregnancies a year. Do you want to lead us?
There have been 10 million since, that we know of since 1967 when and by the way, the Abortion Act came in 1967 in exactly the same way as this bill, by a private member's bill. David Steele, if you remember, leader of the Liberal Party, now the Liberal Democrats, he brought it in, and I think there was something like 24 members of Parliament who voted against it. Now we've got to reverse. People have seen the consequences. I'm not blaming the Abortion Act for this. It's a much wider issue of the issue of the right to life. But people have now seen, even in the short amount of time that we're allowed in Parliament to debate this issue, the very serious consequences of an ill-thought-out piece of legislation like this, such that the majority was only 23. If 12 Conservative MPs or 12 Liberal Democrat MPs or 12 more Labour MPs had voted against the bill, it would have fallen. Now, you would have thought any responsible government would think, hang on a minute, I think we might have made a bit of a mistake here. This needs more time. We're going to have to debate this more fully. But no, they're just rushing it through.
Do you want to lead us out, Calum? Any closing thoughts on this as well?
Yeah, I'll leave with a somewhat provocative thought, which I've mentioned in a couple of talks on these kinds of topics, which is that we've talked a lot about the Rubicon being crossed, with the assisted suicide issue, and talked a bit about the abortion issue. I think they're very deeply connected. I do think that the real Rubicon that was crossed was the 1967 Abortion Act. And one way to kind of see that is this past week, we had these two votes that went through one by one. And we had a lot of really sort of progressive left-wing people opposing the euthanasia bill. They were saying, look, this is going to ruin our respect for human life. Disabled people are going to be particularly impacted. There are going to be mistakes and wrong diagnoses made, all sorts of these issues. But fundamentally, we cannot open the door to killing as doctors. And this is profoundly dangerous. We must respect human life, no matter how weak and vulnerable it will be. Dozens of those exact same MPs 3 days earlier voted to legalize abortion up to birth. And so if you have someone who, like Diane Abbott or Naz Shah or someone like that, who votes to legalize abortion up to birth and then 3 days later stands up and says, we have to respect the sanctity of life. We have to make sure that there are no mistakes. We can't open the floodgates to this sort of thing. We have to make sure that disabled groups are particularly protected. It's just not credible. I can see why none of their colleagues believed them, or half of their colleagues didn't believe them, because they're fundamentally wrong. They got it right on assisted suicide, but their background, their foundation is totally wrong, because the real Rubicon that was crossed 50 years ago was the first violation of the Hippocratic Oath, where it doesn't just say, I will give no deadly drug or suggest anyone to take one. It also says, nor will I give a woman a pessary to produce an abortion. And so, look, I know that's very unpopular in this country. I know only a small proportion of people in this country think that abortion is problematic in that way. But I think this is an opportunity to open that conversation up.
Well, it highlights the slippery slope.
And it highlights the slippery slope. And even David Steele, who brought in the Abortion Act, said it's gone too far, several decades later. And now he's supporting the assisted suicide one, not realizing that the same thing will happen. But I think, for the first time in my life, we now have Richard Tice, the deputy leader of a party, calling Labour baby killers because of this vote. We now have people like Kathleen Stock, a very renowned, prominent feminist, saying this is crazy and Labour have become a death cult. She used the same words. We've seen the overwhelming backlash from members of the public, from a significant number of Labour MPs, from feminists, almost everyone from all the news, and especially from the leading polling party, saying this is crazy and we need to rethink abortion. And so my hope is that I don't expect to convince people immediately on that issue, but I would say, look, this has been a settled issue for 50 years. If we have been sort of misled on so many other issues like assisted suicide, is it time to rethink the abortion issue? Is it time to open up that conversation again to say, can we do better for women? Can we do better for mothers? Can we do better for families? And can we do a better job at respecting human life when it's at its most weak and vulnerable, not just at the very end, but also at the very beginning? I don't think we should be super reactionary or crazy about it, but I think we can at least begin to have that conversation. and encourage people to look into it, look into the statistics, look into the arguments on both sides, because I really do think that we're suffering from silence on these issues. And if we actually debate them properly, we can have a real conversation that can make things better, not only for those children, but also for women and families that might be wrestling with those decisions.
Thank you. Well, it was settled for a long time in America, and Roe v. Wade was repealed. I think we should debate this. That's my personal view. I've learned a lot more in this 2.5 hours that we've had than I learned from any of the public debates. So I appreciate both your time, James, Calum. I think we could discuss this for a lot longer. But thank you so much. Really do appreciate it. And thank you everyone for listening. And yeah, we'll see what happens from here. Thank you. Thank you for listening.
Peter.
Bye-bye.